5 minutes past 10. Our talkback lawyer David Whiting is here to help you with free legal advice. 1300 222 774 is the number if you've got some problems and you need some help from David Whiting. 1300 222 774, and we'll get to calls as soon as we can this morning. David, good morning to you.
Good morning, John.
We managed to deal with family law issues when you were here last week, but I think there's some homework from the week before.
I'd just say on your last week, I thought, normally when I'm not here on a Tuesday, it's because I've left town. That wasn't the case last week. But what an amazing case to talk about from the High Court the week before, Thorne and Kennedy. Are binding financial agreements worth doing? Don't know.
In some circumstances, maybe, but not where they're a rip-off, is my conclusion, if you summarise that case in a tiny little grab.
Well, the problem is at what stage are you equal bargaining power?
Mm-hmm. Well,
and that, clearly the day before the wedding you're not.
No, and clearly you can't advise both sides on a family law contract.
No, they can't do that anyway.
And but people pretty much do. They say, look, I'm going to structure this. Here it is, take it or leave it. And by the way, just go and see someone else before you sign it because you have to go and get independent advice, but it's not going to change. And that's not going to work anymore either.
No. So I think that's, it's made the air a little bit clearer. I was interested in the discussion about the differences between undue influence, unconscionable conduct and duress are all analysed in the case. I haven't extracted them yet, but that's what I got from it. But I had two bits of homework from the week before.
Okay, I can't remember.
One was a gentleman, I'm not sure gentleman's the right word, but let's assume he is, who went to jail and he wanted to write a book about it. And the question was, if he wrote a book about it, was the government going to take whatever it was that he got from the book?
Proceeds of crime.
Proceeds of crime legislation. Yep. And there's legislation in every state and there's Commonwealth legislation as well. And they're entitled to take an order to confiscate literary proceeds, which are any benefit that a person derives from the commercial exploitation of the person's notoriety resulting directly or indirectly from the person committing an indictable offence.
Right.
Or the notoriety of another person involved in the commission of the same offence resulting from the first mentioned person committing the offence. So, I can write a book about I commit a crime. I can write about a book about the bloke I went to jail with. Is the question from the caller's point of view was notoriety, and I can see a really good argument that it's quite possible that writing a story about what you see as deficiencies in the correction system in Victoria is not the commercial exploitation of your notoriety.
Okay, so I'm just thinking this must have come in after Chopper.
Well, Chopper Read is the reason why the legislation came in.
But it wasn't
at
retrospective.
State levels. No, not retrospective.
Right.
And it was brought in at a federal level because of David Hicks and Guantanamo Bay.
Right.
But they actually even changed the legislation, it was there before, but they changed the legislation to make sure that being convicted by a military tribunal.
It's also fine-tuned for Schapelle Corby, wasn't it?
Yes, it has been. So the question then becomes, is it notoriety? Is it commercial exploitation of your notoriety arising from the commission of an indictable offence?
Okay, so if on the other hand you went to prison with barely a whisper from anybody, but you want to write a book about it, and you want to write a book about prison rather than your crime, you may be outside the scope of the law.
Yeah, and even then, the proceeds are, whether or not they take them is still discretionary. They've got to take into account the nature and purpose of the product or activity from which the proceeds derived, whether supplying the product was in the public interest, the social, cultural, educational value of the product, the seriousness of the offences and how long ago they were, and whatever other matter the court thinks fit is all reasonable.
All right.
So that's the first one. Then we had Phil from Ocean Grove, who had a dispute with a lawyer on two levels. First of all, he felt he was overcharged, and the second is he had what you would call a consumer dispute because he didn't get the outcome that he thought he was entitled to. And he'd been to the Legal Services Board, and there are actually three levels of complaint. There's a complaint about a consumer complaint, a cost complaint and a disciplinary complaint, and they're all dealt with slightly differently.
Yes.
So if it's a costs dispute, you are able to go off to VCAT and have them determine it if the amount in dispute is under $25,000. And if you have a consumer dispute, then it really depends upon what happens at the Legal Services Board, because it's possible for the Legal Services Board to mediate in and there to be an outcome. If you get an outcome, then the consumer dispute is regarded as having been settled, and what you do is you get an order from the Legal Services Board that you can enforce as a court order. So, Phil, I hope that's of some assistance.
Excellent. Thank you indeed. Anything else that we of note in the legal system?
Well, I'm planning to watch last night's Four Corners on ABC2 tonight, John. So
about Lionel Murphy.
About Lionel Murphy and 30 years on.
Yeah, I was somewhat caught up with other things last night, and also will catch up with it on iView. In a nutshell, though, the serious allegations raised. Suggestion is that Lionel Murphy was walking both sides of the line.
Yep.
Although he died before his court case could come to fruition, and documents recently released from the archives shed new light on some of his activities that were unbecoming of a judge.
Yes, I think that's a fair assessment. There's also lots of evidence that ought to be around is no longer around, which makes a more detailed analysis more difficult.
It certainly does. Stuart in Middle Park's first up for today. Morning to you, Stuart.
Morning, John. Morning, David.
Stuart.
Situation, I was staying at a holiday complex up on the northern New South Wales coast. Their parking facilities were underground. Was exiting the underground car park, the security door descended and did damage to my roof.
Yes, the roof of your car?
Of my car.
Yes.
I've been talking to the body strata managers. They've provided the information of their insurance companies, and I've lodged a claim on them.
On them? Or how much is the damage to your car, Stuart? What's it going to cost?
About $3,500.
And why don't you claim it on your insurance and let your insurance sort it out with the building insurance?
I thought it would be easier to handle direct. It was quite straightforward. There's no dispute of facts. Yes, I have an insurance company, but I thought it would be straightforward and that they would honour it.
Stuart, I would have thought it was quite straightforward. Is there no... there may be an Australian standard in relation to automatic door closures, I don't know, but I would have thought that the door should not have been capable of coming down if there was someone where the door was coming down to.
They have beams, and if your car breaks a beam,
yes,
then it automatically stops it or sends it back up again.
Yes.
And that was in place.
But so why didn't it work on your day?
I don't know. And their response is probably the most interesting thing. They've actually come back, gone back to them twice, but their final word on it is, whilst we sympathise with the claimant's predicament, we unfortunately must advise in the absence of any negligence attaching to our client, the body corporate, that the liability to compensate the claimant is denied in this instance.
And I understand that, Stuart. What I need you to do is think of the supermarket cases you find from time to time where somebody drops a bottle of raspberry cordial, which makes a glorious mess, and someone else falls over on it. All right? There's clearly negligence by the person who dropped the bottle, but there's no evidence of negligence by the people who manage the supermarket unless you're able to establish that they failed to clean it up within a reasonable time. So if you think about it, the owners' corporation has gone to the trouble and expense of putting the sensors in, and I suppose there might be an argument that they ought to check them from time to time, but it's really, you've almost have to know how long it is since they stopped working, because your negligence is their failure to maintain them.
Yes.
If there were none in place, I'm with you 100%. But you're now talking about, well, when did they fail and how long had they not been working before you drove your car through?
Which I don't know.
And therein lies your problem, and you have to prove negligence.
So it does come down to negligence.
So claim on your insurance and let your insurance company deal with their insurance company.
It's not a strict liability issue. It's a negligence issue. Someone owed you an obligation that they didn't fulfil, and the obligation to take care of your neighbour doesn't extend to checking the beams every day. So, yeah, you have to prove they were negligent. Sorry, Stuart. I mean, I personally would give it a run, but not for $3,500.
Well, you'd have to spend a fair bit.
Yes. What you might do and look and see if there's an owners' corporation legislation in New South Wales that will give you a small claims jurisdiction.
Stuart, that's why people have insurance, is my attitude. I differed with David. I pay insurance so I don't have to have these hassles. That's what my insurance company's there to do for me.
Yes, and we're always there as a backup, John. I just was interested in the process.
Well, it depends how much time you want to spend frigging around doing the work of the insurance people. That's why you pay them a premium. That's why you've got them there. Something goes wrong, you claim.
All right, gentlemen, thank you very much.
Stuart.
I've got a different attitude. I'm much more ruthless and pragmatic than you, David.
If Stuart had walked into the office, I'd say, well, now let's see how much cheque you need to write first. We're principles as well as practical.
Nick in Northcote. Morning, Nick.
Good morning, John. Good morning, David.
Nick.
I called the two of you gentlemen about almost 2 years ago. My wife and kids were living in the Northern Territory and we were renting out our property. And our neighbours, while we were living away, decided to knock down their house and start rebuilding.
Yes.
In the process, they temporarily moved our joint fence about 1 to 1.5 metres back over our garden bed so that they could get access to their property to put down the foundations for a new wall that was going to be built
on the boundary.
On part of the boundary.
Yes.
During that process, they caused some small damage to our property, the garden bed, garden lighting, watering system. And in February this year, we moved back into the property. When we moved back in, we noticed some additional damage in the form of a water tank, which we believe in the process of knocking down their house, someone has busted the pipe that was attached to the fence and has caused water to run under the house. And
under your house or their house?
Under our house,
right. And
has also meant that the tank has then, all the footings have deteriorated and the tank with 5,000 litres in it is leaning against the side of our house.
Ouch, yes.
I contacted the owners. I first pointed out the problems to the builder back in March of the previous issues and the new issue that I found. I then contacted the owner of the property, our neighbours, in April and told them of the problem. They sent their builder around to inspect the issues, and while the builder predominantly said with most issues, I disagree that we've caused these problems, he wrote to me and said, in good faith, we will rectify the things that you pointed out. I've had several conversations with the owner on the telephone, in person, outside their property. The build is almost finished. The property, they've built two new properties next door.
They built two units on the one block, yes?
Yes.
Yep.
They're about to sell one of the units in the next 4 weeks or so, and they'll move into the other property themselves. They're doing nothing to address the issue, and I'm concerned the builder. It's only a small amount of money, David. It's probably $3,000 or $4,000. It's not a lot. But we feel very strongly there's a principle that they've totally done the wrong thing by us, and they haven't come and
Nick, your claim is against the builder. Your claim is not against the owner.
Right.
So you can bring a claim against the... Have you spoken to the building surveyor?
I've spoken to...
Because they will have received a building permit from the building surveyor who is required to ensure that there is no damage caused to your property during the course of the building works.
Yeah.
And it's called a protection works notice. So he should have given you a protection works notice.
But they haven't. I spoke to the Victorian Building Authority and they advised me that if we wrote to the owners and they didn't rectify the issues, then they would send out a person to inspect the site, collect evidence, and if they felt there was evidence that the protection notice had been breached, then they would write to the surveyor and tell them that they believe that had been breached.
Nick, but that doesn't make the owner liable. What I'll do is my view is it's the liability of the owner, of the builder. It's also possibly the liability of the building, the guy who issued the building notice, the building surveyor, because there's supposed to be an insurance policy in place to protect your property. Now, that may or may not have occurred, and that's something that the building surveyor should have looked at. So I listen to it for next week, and I'll consider the builder and the building surveyor. I tend to think it's the builder. I don't see it as being the owner.
I would have just assumed if they had employed the builder that they are ultimately responsible, David.
Okay, we have a concept called vicarious liability, and that is when you are liable for the actions of each others or for another person. We consider that to apply when you've got an employee, not a contractor. So if you employ someone as a plumber or an electrician and they cause damage during the course of the work they're doing, that's not seen as being, because there's no master-servant relationship, that's not seen as being the responsibility of the person who engaged them.
Nick, listen in. As David said, he'll have some more details for you next week. Louise in Windsor. Good morning to you, Louise.
Good morning, John. Good morning, David.
Go right ahead.
3 weeks ago, I wrote a petition after having discussions with a few colleagues. Hello, you there?
Yes, we're here.
Oh, okay. Yes, after having discussed with a few colleagues, I felt very strongly about their situation. So I wrote a petition to the kindergarten management, and 4 days later,
I take it you're working for kindergarten?
Yes.
Yeah, or you were working for a kindergarten. Yep.
Yes, for this particular kindergarten association.
Mm-hmm.
Yes.
And
after I wrote the petition 4 days later, I was sacked.
Well, if you were sacked in those circumstances, it seems to me to be harsh, unjust and unreasonable, and you've got the ability to bring an action for damages, and you've got the ability to seek an action for reinstatement.
If indeed that's what you want, to go back to work for people who sacked you.
So they're your rights. You have the right to go, and there's a concept called a protected period, and the protected period, or a minimum period of employment, depending on whether it's how many employees they've got, and in that period there are normally no damages applicable for termination, but it doesn't mean that a termination can be harsh, unjust or unreasonable. Even if you certainly couldn't get reinstatement.
Even if Louise is casual.
Even if you're casual, but there was a case decided earlier this year in New South Wales, where someone was working in an RSL and there were some shortages of money and some issues, and they were found there was compensation payable to the former employee on the basis that the termination was harsh and unjust. All right.
Right. So who do I go to make?
You would need to talk to an employment lawyer. So you would be looking, you might talk to someone who does it on a no-win, no-fee basis, but you'd need to talk to an employment lawyer about what your rights are and what your measure of damages might be.
If you need to find a referral to a lawyer who's a specialist in any particular area, Louise, the best thing to do is to ring the Law Institute of Victoria, who offer a referral service to people who are specialist practitioners in particular areas of law.
Right.
That's free, and you do that by ringing the Law Institute of Victoria on their helpline.
Right, I see. Okay. All right.
Anything else, Dave?
No, that's it.
All right, Louise?
Right. Okay, thank you very much.
Thanks,
and
Louise.
good luck.
Okay, thank you.
Rodney in Ashwood. Good morning to you, Rodney.
Yes, good morning all. Good to see you. Okay, now I live in Melbourne, but I've got a property down in Gippsland, a few acres are down there where you escape to wherever you possibly can. I keep a four-wheel drive down there. It's very much a workhorse type of thing, cutting trees around and whatnot. Now, it recently developed a problem with the steering, and I took it to the local garage, and the garage bloke said, needs a bit new steering box. So I've got a steering box, reconditioned one here in Melbourne. Took it down. But he had a go at it. He put it in. He said he's having trouble working out what to do, and he's been in touch with people who specialise in that sort of vehicle. But it's still not right. He sent me a bill for $1,500, which doesn't include the steering box that I provided, but it includes a power steering pump of $560.
Right, Rodney. Rodney, is the problem with the steering box that you provided, or with his installation process?
That was his installation process. He said himself he'd never done one of these, and he rang the people who specialise in that type of brand, and they tried to guide him, but he said he'd never done one before, and he admits it's not working properly.
So why is he chasing you for $1,500?
He's chasing me for $1,500. It includes a steering pump, which is $560. I'm not going to dispute that.
So he's seeking payment for parts as well as for labour?
Parts and nearly $600 in labour.
Rodney, you need to decide whether your contract was for him to try or for him to succeed.
Or
for the work that he was doing or the outcome?
Some say again?
So, for the work he was to do, the time he was to spend, or for the outcome?
The outcome is what I was looking for.
Well, I know we're all looking for an outcome.
Yeah.
On what you've told to me, he's entitled to be paid for the parts, but probably not for the labour.
Well, that's what I was thinking, yeah.
Yeah.
Yeah, the parts, I don't know why he had to put a new steering pump in. I've got no idea, $600 worth. He never discussed that with me. He never told me anything about that. But
you then even get to the question of whether a new steering pump was necessary.
Yeah,
But your starting point, Rodney, means to go and get someone else to look at it,
right,
to see what needs to be done,
right.
Because and then what I'd be doing is comparing the cost of what it would have been if you'd started from scratch.
Yeah.
And then the costs that you've paid him. So if you'd simply taken it to someone who did this all the time, what would have cost you?
Yeah.
You now build on his work and get someone else to finish it. What is that now going to cost you? And then make a decision about how much of the extra $1,000 he gets to keep.
Right, okay.
Okay?
I'm happy.
I don't want you to lose by the process.
No.
But if he's given you some work that you can benefit from down the track, then I think you should get paid for it.
Yeah, okay.
All right.
Fair enough.
Thank you, Rodney.
Okay. Thanks, David. Bye.
The Court of Justice Whiting is convened. Cheryl and Rosanna. Hiya, Cheryl.
Hi. Thanks for taking my call, John and David. Look, I'm ringing on behalf of my mum. She's 91. She's in a nursing home down on the Mornington Peninsula. And we have decided as a family that it's best to come up closer to family. I live 6 minutes from the nursing home we'd like her to move to.
Yes.
And she's in agreement with that. Just having done some research with the two facilities, I've been told that when she leaves the one she's in now, it's they will charge 7 days accommodation no matter how soon we move her. And the one she's going to be moving to at some point when the beds become available, that we need to decide within 24 hours and move her within 3 or 4 days.
Yes.
So I'm just thinking there's obviously a bit of overlap of having to pay for two facilities, which is sort of understandable, I suppose, between 3 and 7 days of double payment.
Yes.
But also I've been told that they won't release the RAD, the refundable accommodation deposit for 14 days, which means she's having to pay up to $1,000 more for the first up to 14 days.
Cheryl, what you've done is you've signed your mum has signed a residence agreement with an aged care facility.
Yeah.
Okay? She now wants to sign, or has signed, a residence agreement with another aged care facility.
Yeah.
And if you look at the first agreement that says is that the RAD, the accommodation deposit, is repayable within 14 days of departure. Okay?
Yeah.
And you'll also find, and I think that's fairly reasonable. It applies whether you die or you leave voluntarily. If you die, it's 14 days after a grant of probate. But it's, in a sense...
You've got a bridging problem then.
Well,
right.
What actually happens, John, is you make a RAP, a residence accommodation payment to the new facility, which, depending on how much it is on a RAD of $550,000, the RAP, these lovely buzzwords, is $89 a day. Mm-hmm. So if
so you
they
pay
are
the
the
daily
numbers,
fee until you can pay the lump sum.
Yeah, in aged care you pay a care fee, an accommodation fee, and an extra services fee. So the accommodation fee is $90 a day, or on a bond of $550.
So Cheryl's problem is not insurmountable. It just might cost a little more than it might have otherwise.
Well, yeah, the answer would be is that what she's in a sense fussed about is that she's got an agreement that says, I've got to give you money back 14 days after you ask for it, and you've got to give me 7 days notice or payment so that of the daily care fee before you leave. In the overall, that's about right, isn't it, Cheryl?
Yeah, that's right.
So the difficulty. I mean, it's not as if they're the same aged care facility with the same staff and the same owner.
No, that's right.
So what you're saying is that what you want to do is rewrite the accommodation agreement that you reached with the first one. They're certainly not obliged to.
Sure. I suppose just because the RAD is being kept at the first facility, I'm having to pay 100% of the DAP, the daily accommodation payment.
Yes.
the 14 days, even though the mum has got the money, but it's not being released. That's my concern. I suppose.
Well, they have 14 days in which to pay it. I act for a couple of aged care providers, and the issue is that they're required to have facilities in place to ensure that the payments can be redeemed can be paid out in an appropriate time, but it's not as you are taken out in your wheelchair, here's the cheque.
No.
Okay, so it's a financing issue more than anything else.
It is, exactly. That's what my concern is.
So they might not take 14 days, but they might. Yeah. They might also have an obligation to pay you interest. You should look at that as well.
Okay, I'll find it out.
All right, Cheryl.
All right, thanks for your help.
Thanks, Cheryl.
Bye.
Good luck on that. David, can we squeeze in a few more, because we've dealt with some complex problems and there are a lot of people who are still holding who have been on hold for a long time. So we'll get a few more calls with David after the news headlines. It's just after 10:30. It's 29 minutes to 11 and Kate Draper's got the headlines. Thank you, Kate. Ellen in Heidelberg, good morning to you.
Oh, good morning. Thank you for fitting me into your program. Look, for the last 6 months or more, I have been searching for the title for my home, which I paid off about 10 years ago.
Yes.
And I've been in contact with the lending institution / their solicitors. I've been told that the lender has merged or amalgamated or whatever.
Or branches have closed or all sorts of things
have closed, etc.
Tell me, Ellen, is the mortgage on your
home?
So it's on your home. Is the mortgage still registered on title?
Yes. Now, I've done an issue search, if that's where you're heading.
No, the issue search is now, most banks moved about 3 months ago to electronic titles.
No, it's not on an electronic title. I paid it off about 10 years ago.
Yes.
And really, Dave, what I want to know is I've been going on a merry-go-round for the last 6 months, talking to everybody, and I simply want to know, when you have an undischarged mortgage, and it goes missing, is it up to me to bear the cost of getting a new one issued?
No.
No.
It's up to them. It's up to them to give you the title that you're entitled to as the owner of the property. It's up to you to pay the costs of having the mortgage discharged.
Yes.
But the title replacement is their problem. Have a talk to the Financial Services Ombudsman.
Oh, okay.
Right, because the Financial Service Ombudsman will come and will say to them, look, all the evidence is you've got the title. You've got no evidence of having given it to Ellen. It's up to you to give it to her. Now do so.
Yes, okay. The only problem I do have is that keeps changing.
There will be a successor at law to the lender shown as the mortgagee on your title.
Yes, there is.
Right?
Okay.
I mean, I've got an equally silly one from a bank in the north of us, where what we have is that person who was shown on the registered owner on the title has died. Before she died, the loan was paid out and their bank account was closed. We now want to discharge the mortgage, and the lender says the mortgage discharge fees needs to come from an account at our branch, at our bank. And my difficulty is we don't have an account at your bank. Does that mean we can't have a discharge?
Why does it have to come from their branch of their bank?
Well, their bank. I don't know, John.
That's ridiculous.
They all make slightly mad rules.
You should be able to pay it any way you like.
Yeah.
They can't refuse it if it's offered by some
I haven't gone to the banking industry ombudsman. I'm trying to be nice first.
Tiny little fee. I mean, that's just someone's made up that rule and they're trying to enforce it. By what power, as we've been taught to say. All right, well, good luck. I hope that helps you, Ellen, and good luck with your expedition. And Susan in Bentley, you will be our last caller with David today. Morning to you, Susan.
Hi, Susan.
You can be Susan. Yep.
I can be. I just have a question about my liability for damages that my 16-year-old son, caused to somebody's 2-week-old BMW when he crashed into it a few months ago. He was riding an illegal motorised bike on the road, and he didn't stop at a stop sign because his brakes weren't adequate for the power of the bike he was riding.
Right.
Sorry, just to clarify, this is a bicycle?
No.
Yes.
That's been motorised with an electric or a petrol motor?
A petrol motor.
With a capacity that is that you need a licence for. Yeah, okay. Yes.
But he's a 16-year-old boy. He thinks he knows everything.
Not to be told.
Yeah.
Yes. Yep.
Most importantly, was he hurt or anyone else hurt?
Well, he sustained a leg injury, but he didn't need medical attention for it.
So he'll be okay, and no one else was hurt. That's what
no
really
one
matters.
else was hurt. Yeah, but there's a $3,600 damages bill that an insurance company is pursuing him for, plus costs. And I don't have $5,000 to pay for it.
It's your son's problem, Susan, not yours.
Good.
You're not hear me out. Your son has civil liability.
Yes.
Right? He can be sued for damages.
Yes.
Okay. And if he was sued today and a judgment was granted today, that judgment could be enforced or relied upon for a period of 15 years.
Oh, wow.
Now, I don't know that anyone will remember long enough for it to be an issue.
Yeah.
I'm simply saying it's not, personally, Susan, it's not your problem.
Good.
Okay?
Good.
It's something that your son might need to deal with.
Yes.
But he certainly doesn't need to deal with it right here and now if he's not able to do so.
No, he has no job. He has no income. So
with the presumption is he'll still be learning for the next 5 or 6 years anyway.
Yes.
So he'll be studying.
Yes,
Susan, it's a good learning experience for your 16-year-old, and one of the things he can learn is how to write back to the insurance company by going and visiting the local free community legal centre.
Yes.
Getting advice and getting them to write what's called in the trade the haven't got a cracker letter.
Oh, he's already written one of those, and he's put his personal twist on it. Some of it I had to remove because it was a bit too personal, but he's already done that. So he has written back to them and said, I'm 16, I'm unemployed, I don't have any money, so if you want to take me to court, then good luck.
Okay. You're well ahead of the game, and he is learning the lessons of life at a accelerated pace.
All right, thanks for your help.
Good luck then, Susan. And it's a time of considerable anxiety when someone dear to you is
under that kind of issue,
the full weight of the legal system, and you're wondering if you're perhaps next in line. Yes, I can understand Susan's anxiety.
Thank you, John.
Not that I'd ever have done anything similar myself, nor would you have, David.
Which particular aspect are we talking about, John?
Having done anything naughty as a 16-year-old boy.
It's not America, but I'd take the fifth, I think.
The first time after I got my driver's licence that I went out in a car on my own was in my mother's car, and at an intersection not far from home, the lights turned green, and I very gingerly, on my own for one of the first or second times, put the car into first gear, and as the lights changed and the car in front started to move, I moved too. But I bunny hopped.
Oh.
And I hit the back of a Jaguar.
Oh.
Fairly gently, but I did make contact. Immediately the woman jumped out and said, "Oh, my transmission's broken." And I went, "Ah!" Anyway, as it turned out, of course, there was something wrong with the transmission of her car long before, but that's why she hadn't moved. When she started to move, she stalled. I bunny hopped and hit the back of her car. Everyone just sort of went, yeah, well, we'll see what happens here. And
it's just a light sweat for a few hours.
Yeah, nothing eventuated. I don't think I've ever told my parents, if you're listening this morning.
Thank you, John.
That's my equivalent. Thank you, David. David Whiting, Melbourne lawyer, helping you with free legal advice, as he does at 10 o'clock on a Tuesday morning. It's 19 minutes to 11.